In a high-stakes legal drama, former judges, prosecutors, and government officials have entered the ring, filing a separate amici brief in support of Mark Meadows, the former White House chief of staff, in his ongoing legal battle. Meadows faces indictment in Georgia over his alleged involvement in efforts to overturn the 2020 presidential election results. Notable figures among the group of supporters include Donald Ayer, a former U.S. Deputy Attorney General, John Farmer Jr., former Chief Counsel to the Governor of New Jersey, Charles Fried, a former Associate Justice of the Massachusetts Supreme Court, and others with extensive legal backgrounds. Their argument centers on the principle of state authority. They contend that the U.S. Constitution grants states a compelling interest in prosecuting cases related to interference with federal elections within their own courts. They emphasize a long-standing judicial policy against federal interference with state criminal proceedings. The supporters assert that the charges against Meadows, and by extension former President Trump, lack a substantial connection to their official duties. This dismisses not only claims under the Supremacy Clause, but also defenses invoking the First and 14th Amendments. At the heart of the matter is the question of whether federal authorities can intervene in cases involving alleged election interference, or if these matters should remain under state jurisdiction. The legal battle highlights the complex interplay between federal and state powers in the United States. Mark Meadows has a looming deadline to file his response, and the case promises to be closely watched as it delves into significant constitutional and legal issues. The outcome may have far-reaching implications for the balance of power between federal and state authorities in election-related matters.